2022. Whereas equitable tolling says, well, I've been dealing with that court case that was built by the supposed People's State of so-and-so versus John Doe. I've been dealing with it since January 1st, 2020, and I finally got rid of it in July 1st, 2022. Okay, now I'm going to sue. Why? Well, because equitable tolling says that if I had actively participated and dealt with previous claims, and then out of those claims that I've actively participated in, or because of those claims that I've actively participated in dispelling, it prevented me from bringing this claim. Therefore, in good faith, I am only now bringing it now, and statute of limitation doesn't apply because equitable tolling allows it. That's equitable tolling. Accrual says I am simply just figuring it out now, regardless of whether I've been dealing with it and the cause of me dealing with it that prevented me from bringing this claim now is because of the man that I'm now suing, aka equitable tolling. Regardless of that, I'm just figuring this out because I could not have reasonably realized that I had a claim that is complete, or a claim that could create a present cause of action, until I found this document. And there's no way I could have found it out, or until that case had ended. And in order for me to claim malicious prosecution, which requires that I vindicate myself first, I need to first dismiss that case. And that case took 2 years. The accrual is to my favor. Thus, statute of limitation is inapplicable in this instance. In other words, ladies and gentlemen, here's another way out of statute of limitation. The will of slavery, when it comes to pen and paper, is built by tortfeasors to make it easy for them. Then they realize that itself could be an issue for them, so they leave ways out for those who are willing to figure it out, and for those who are willing to do the mental toil. As with any other content, I implore you to listen to it and take the time to digest it. Just take the time to know the difference between equitable tolling and accrual, and how they can relate. But most importantly, how they both exist for the purpose of countering that trash called statute of limitation. Statute of limitation is the easiest means for someone to throw at you to say, oh, well, because you coming in late now, you can't do anything. Too bad, bye-bye. Yeah, we damaged you and we're not even going to deal with it because, well, you came a little bit too late. Not our fault. You know, someone died, oh well. Someone lost a lot of money, oh well. Someone went through a lot of trouble, oh well. We violated the law, oh well. You came in late. But there's a solution called accrual, as in this case that we're showing, and in prior videos called equitable tolling. Again, accrual is what sometimes where you hear someone says, quote, fraud has no statute of limitation. Sure it does. Sure, fraud has statute of limitation. It's in most states. There it is. In Alabama, statute of limitation for fraud is 2 years. That's the code for it. In Alaska, it's 2 years. That's the code for it. Arizona, it's 3 years. Arkansas, 3 years. California, 3 years. Then goes on and on and on and on and on. Kentucky, 5 years. So don't let people fool you when they say fraud has no statute of limitation. Something causes fraud, or any claim for that matter, to not have statute of limitation. The triggering mechanism that allows such a magic to occur is what you should seek after. It's called accrual. In some cases, they call accrual discovery rule. So that's one, discover or accrual, which is usually one. And two is equitable tolling. So it doesn't appear like I'm leaving you hanging. When I say discovery rule, it's the same thing as accrual. It's different words for the same thing. Here's what I mean. There's a definition of discovery rule. The discovery rule, in general, the state of California has a statute limitation of 3 years for the crime of fraud. However, this is a very general rule that has many exceptions. These exceptions are the triggering mechanism to remove that limitation of 3 years to which you can bring the claim, which is what you must know. One of them is discovery rule, aka accrual, which is mentioned. But here's the definition of discovery rule. When considering a statute of limitation, it is important to understand the discovery rule. The discovery rule states that a statute of limitation does not begin when the actual crime occurred. It's just the first instance example that I gave. When it occurred. 2, when you now realize you've been damaged, your knowledge of damage. And 3, the maturity of it by way of that. Discovery rule states that a statute of limitation does not begin when the actual crime occurred, but instead begins when the victim of the crime becomes aware that it actually happened. Your awareness and knowledge that you were damaged is separate from the instance itself that gave rise to it. Attorneys will try to merge that and put it into a knot and a link as though it's the same thing. It is not. You must know this. This rule is very important because victims of fraud do not always realize that they are victim until the fraud has been going on for quite some time. If there were no discovery rule, many victims could never file charges for this type of crime. So we've shown different instances and examples. It's not just fraud. It's not just dealing with damage when it comes to product or services. It's any circumstance. Know this. The event, the knowledge of the injury, and the maturity of your cause of action are 3 separate issues that you must figure out before constructing a suit. Don't be a victim. Know these basic things. Until next time, take care. Best of luck.